This channel does not promote any violent, harmful or illegal activities. All content provided by this channel is meant for an educational purpose only.
I'll just give it point formulas. 1. It is admitted that 65 are off. That's the 65 lakhs are off the list. That is the affidavit of the receipts all over the press also. Now, why do I call it a state of hand? Is because 65 are off the list, 65 lakhs. By this delightful word called non-inclusion. Non-inclusion means that for the month of July, when the matter was pending here, he asked you all to fill up enumeration forms. We are not looking at any documents. Well, the original thing when we came to court was documents in July. That was changed, and we look at documents after you file the enumeration forms. So these 65 are those who on the enumeration forms received without any documents, without any hearing, without any notice, without any process, are told, not told in fact, declared that because you are one of 3 categories, you are off the rolls. Which are those 3 categories? In the 65 lakh forms we have received, I, the Election Commission, declare that X lakhs are dead. Y lakhs are permanently shifted or absent. I have the breakup, it's 22 lakhs, 33 lakhs. And finally, 7 lakhs odd are duplicated. You are already enrolled. It's a duplication. Now let's forget the details. Just look at the concept. This is done by a procedure nowhere in the ROPA, nowhere in the rules, nowhere anywhere in any manual. Procedure is what? I give out a press note saying all of you please fill enumeration forms. That's it. I don't ask for documents. I don't have an interview. I don't check, etc. As far as physicality is concerned. What I do is I get the form, then I go maybe to others XYZ Tilak Mark. And on talking to people, I declare you either dead or shifted permanently not found, or already I go and check the name somewhere else. Now, why I said non-inclusion is a delightful word is because this is nothing but de facto deletion. 65 lakhs have been deleted by the delightful ambiguous phrase of non-inclusion by an enumeration form under a procedure nowhere, not a comma, full stop anywhere. That's point 1. Point 2, nobody is against deletion. Nobody is against deletion. You can have deletions. Of course, you must have deletions there. Point 2 is that point. Point 2 is that your lordship has a very detailed fasciculus of rules about deletion. Occupying the field. It occupies the field. No legislation is required. It is common ground that you have not followed that procedure. By the delightful use of the word non-inclusion, had you used the word deleted, you'd have to use those procedures. So on that, just note the clause and I am done. The clauses for these 3 categories are, so first category is dead. Dead in this case on enumeration form. So technically, I mean, there are many cases. You say, whether other might have shown lots of yesterday. There are many cases. But a dead man says, I am not dead. In my enumeration form, somebody is presumably dead. But he has not had any hearing, any process. Now, just note the dead category is your option is 4A 219. I'll just make a 50 the cross number, then I'm done. Volume 4A 219. The basic point I'm making is 219. The basic point is that this is in law and in fact a deletion without following the deletion any process, any rule, any natural justice, any notice, any adjudication, nothing.
Are you referring rule 18?
Now first is 219 at the foot of the page. The larger column, the larger number is 10.2.13 at 219 of 4A. At the foot of that page, there is an SOP to be followed in suo motu deletion. Nobody is challenging your power to do it, but do it by system. Do it by what you have yourself prescribed. SO, may I read this? Bottom of
Yes,
this
you got it.
Bagchi.
That certificate from the competent authority.
May be done suo motu without form summons, without further inquiry. The identity established with reference to death certificate or after field verification on the basis of death certificate from the competent authority obtained by BLO, whereas Austin is certain they have not got the certificate. Could not have in one. List of deceased electors collected, etc., etc. Whole SOP is there. Then come to the next page, 10.2.14. Your Lordship is not concerned with the minutiae. Your Lordship is concerned with the admitted fact that I have not followed this because it's non-inclusion, not deletion at all. What are you talking about, Mr. Singh? This is not deletion at all. I don't follow this rule. I have not included. Deletion of the names of shifted electors from the electoral rolls. This bang in the middle of 220.
Yes, sir.
And the third category is the so-called duplication. Is a residual legatee at 221 bottom. A residual category 221 sex scenario B for all other cases of deletion in the name of shifted elector following SOP. This is shifted, I'm sorry, this is shifted. Now let's just see 222. This is very important. This is Bagchi will take also 222. Very important.
Triple two.
Continue next pages. Triple two.
Next.
The small Roman 4. This is Bagchi's problem. No suo motu deletion shall be done in an election year. When a general election to the state assembly or the House of People is due in the state concerned during the 6 months preceding period, 6 months period ending on the date of expiry of the term of the said House. However, suo motu deletion can be done in special circumstances after obtaining the Commission's approval. Fellows, what is the intent? It's a very clear intent to be fair, to have a process. When I say you have it before an election which is 6 months later, 9 months later, that is for that particular state. Obviously, not because you go and have a for the whole country in 2000 December when the Bihar, the West Bengal elections are 2 months away after that. That's not the object of my submission. So, fellows, these are my submissions. May I just, fellows, and see, fellows, the press note, Arunachal is very. This same thing happened in 2004. Arunachal and Maharashtra, I believe, were exempted because they were around the corner. See the consistency and the inconsistency now. Just turn to say 414. Just turn to 414. This is the one-time wonder when the election commission is not following its own rules. Yeah, I said so. 414. Same volume.
Page 41.
Part 2. It's volume 4A.
Part 2.
Part 2. I'm very sorry. This is exactly what happened in the 2004 scenario. And in fact, they went on with the other elections, which are further away, but they exempted Maharashtra and Arunachal Pradesh for this very reason. And rightly so. Because you can't have a time squeeze, like a tunnel squeeze, for such an important activity.
Yes.
414, my lords have got, Justice Surya has got, Justice Bagchi has got. Yes. You have a page for this? Look at the number of states. Jammu and Kashmir, Tripura, Nagaland, Mizoram, Meghalaya, Manipur. And then, next para, they exempt only 2 mothers. Maharashtra and Arunachal. Read that, brothers. In the states of Arunachal and Maharashtra, general elections are to be held in the later half of 2004. And therefore, the program in these 2 states will be announced after the completion of general elections. And the table below is all 6 months hence. The table below is 6 months hence. This is one of 3 months are taking now. Then the next page is further table goes on. Very deeply applied. Your possible, we are seeing for a stay as well. Yes.
Yes,
you can consider that request. Very deeply of them.
Well, if I can address your lordships on behalf of the main petitioner, Association for Democratic Reforms. This petition also has 5 voters from the state of Bihar in it. I independently appear for the state of West Bengal as well, who have just as of 3 days ago received a similar notice to the state of West Bengal, whose elections are next year.
The state of West Bengal, nothing happening right now.
There's a notice which we have received on 8th of August, which has just been received. So they are commencing the process already, and this is without consultation of the state government at all. But I'll address that later. Allow me to first address on the main aspect. What I believe is the edifice of our case, Manoj, is this. If you see the provisions of the Constitution, there are 4 articles that specifically deal with electoral rolls. That has not been read to your lordships. I'll just read that. The entitlement to be on the electoral roll is a very sacrosanct one, which is available to us as voters in this country. Just please first take Article 324 for us for a minute. And then I want to show your lordships both the acts, 1950 and 1951. We can come to the rules and forms, etc. later. Article 324.
Yes.
Superintendent's direction. The superintendent's direction and control of the preparation of the electoral rolls for and the conduct of all elections to Parliament and to the legislature of every state and of elections to the offices of President, Vice President held under the Constitution shall be vested in a commission. Now the rest of it deals with the commission, and that's what fell for interpretation in the before the Constitution bench in Anup Beranwal, who actually many observations of which are helpful to us. I'll bring your lordship to that. 325. No person to be ineligible for inclusion in or to claim to be included in a special electoral roll on grounds so and so. There shall be one general electoral roll for every territorial constituency for election to either House of Parliament or the House or either House of the Legislature of a state, and no person, please mark this, shall be ineligible for inclusion in any such roll or claim to be included in any special electoral roll for any such constituency on grounds only of religion, race, caste, sex, or any of
That's it.
That's now 326. Ironically, the only provision of these 5 which doesn't use the phrase electoral rolls is the most important to us. The elections to the House of the People and to the Legislative Assembly of every state shall be on the basis of adult suffrage, that is to say, every person who is a citizen of India and who is not less than 18 years of age on such date as may be fixed in that behalf, by or under any law made by the appropriate legislature, that will be the 1950 Act, and is not otherwise disqualified under this Constitution or any law made by the appropriate legislature on the ground of non-residence, unsoundness of mind, crime or corrupt or illegal practice, shall be entitled. It's an entitlement that the Constitution is giving me to be registered as a voter at any such election. 327 and 328 use the same phrase, but just make it clear that Parliament can make a law and subject to it, state can make a law. But they use the phrase electoral roll. These 5 provisions have to be read together to show how the wheels of democracy function in this country, with the Election Commission steering. It is very clear that the electoral rolls are subject to only the disqualifications which are provided in the Constitution and anything else which the law may provide. The only other disqualification or qualification which is provided under the law is that which deals with residence. Of People Act 1950, but not the 1951 Act. So if your lordship can just take the bare act of the 1951 Representation of People Act, it will be the same book. In the bare act. 50 के बाद, it's the same bare act. 50 के बाद 51. Section 2E.
और मेरे को दूसरी में है।
This is of the 1951 Act.
Section 2.
2E for England. Rogers and Bagchi, it's the second letter. Section 2E. Elector. I have a compilation in which I've extracted it. The last page is this. That makes it correct.
Yes.
Section 2E. Elector in relation to a constituency means a person whose name is entered in the electoral roll of that constituency for the time being in force and who is not subject to any of the disqualifications mentioned in Section 16 of the 1950 Act. Now please come to Section 62 of this Act. Section 62. What's other?
Right to vote.
Right to vote. Allow me to read this. No person who is not, and except as expressly provided by this Act, please mark those words, those are critical. Provided by this Act, every person who is for the time being entered in the electoral roll of any constituency shall be entitled to vote in that constituency. So the minute my name is entered in that electoral roll, a statutory entitlement at the very least arises. Whether I can raise it to a constitutional right, I believe I can, because the majority in Anup Paranwal says so. But I can even just pitch it here at the statutory level, because right now their enumeration form and everything else that flows from it has no basis in constitution, in the either of the acts or even in their rules. There is no such thing. It's a figment of their imagination that they come up with a document, shove it on 8 crore people and say start supplying it. There is no such thing. They needed to amend the Representation of People Act to take my entitlement away. That they haven't done. Let me continue reading this. No person shall vote at an election in any constituency if he is subject to any of the disqualifications referred to in Section 16 of the Representation of the People Act. No person shall vote in more than one constituency of the same class. Fourth one, no person shall vote twice in the same constituency. Fifth is the disqualification of being in prison. See the second proviso after that, at the bottom of that section. Provided further that by reason of the prohibition to vote under this subsection, a person whose name has been entered in the electoral roll shall not cease to be an elector. So even if I am in jail, even if there is a question of voting rights, etc., I will not be thrown off the electoral roll. Parliament has said so. Parliament has secured for me my right the minute I get onto the electoral roll. And why does Parliament do this? Parliament does this because, if your lordships would now see the 1950 Act. It's the first one in that paragraph. The 1950 Act makes the entire procedure so very absolutely strict that if you want to remove me, then you have to first initiate an inquiry, conduct that inquiry for me. The small little man, as Justice Krishna has said, going into a polling booth, for that one person, you have to conduct that inquiry. You see the 1950 Act. Allow me to take your lordships first to Section 2 of that Act and the definition there. It defines assembly constituency, council constituency, etc. But Section 2, subsection H of the 1950 Act.
Section
2 H. H for Himachal Pradesh.
that is prescribed.
Prescribed means prescribed by rules made under this Act. I am showing you lordship the flow of this because our founding fathers were prescient enough when they brought in the constitution and realized we need to have some law in place, that they brought it in the same year. It's the same Constituent Assembly sitting as the Provisional Parliament which did all this. And they were aware of the fabric that they had to create to secure our voters in this democratic system. So H says prescribed, because the word prescribed is employed later. For a minute, please come to part 3 of the Act, my lords, which starts with section 14. (14) defines constituency and qualifying date. And here your lordships will find this as expression, which will better help us understand how the Election Commission goes about its job. Qualifying date in relation, that's 14B, my lords, have it? Qualifying date, section 14, subsection B. Qualifying date in relation to the preparation or revision of every electoral roll means the first of any one of these months of the year in which it is so prepared or revised. Please note, preparation and revision disjunctively, 2 separate processes to be undertaken. Section 16 provides for the disqualifications, my lords. Not a citizen, unsound mind, and corrupt practices. And see subsection 2 of section 16. So section 16(1) is dealing with disqualification for registration in an electoral roll. So at the threshold, when you start registering voters, these are reasons why you won't put that man's name on the roll. Please see 2. The name of any person who becomes so disqualified. So this is at a later stage. After registration, so that there's no doubt now, after registration, shall forthwith be struck off the electoral roll in which it is included, provided that the name of any person struck off the electoral roll of a constituency by reason of a disqualification under 1C shall forthwith be reinstated in that roll if such disqualification is during the period such roll in force, removed under any law authorizing such removal. Admittedly, the 65 lakh figure that we have with the breakup that has been given by them is not on any one of these 3 grounds of disqualification. It's not on lack of citizenship, unsoundness of mind, or corrupt practices. It's not on that. If it's not on that, 2 doesn't kick in. If 2 doesn't kick in, I could not have been thrown off the electoral roll. Parliament says. Please come to section 19. Conditions of registration. Subject to the foregoing provisions of this part, every person who A. is not less than 18 years of age on the qualifying date, and B. is ordinarily resident in a constituency, shall be entitled to be registered in the electoral roll for that constituency. So there's conditions of registration. Disqualification from registration, 16(1). And then once you're in the electoral roll, 3 limited points on which there can be a removal from that electoral roll. Section 20 deals with ordinarily...
Mr. Gopal,
yes,
don't you feel 16 and 19 must be read together?
100%. I say so.
And that is where...
19 first, then 16.
That is where
Yes.
the shift of residence
Yes.
is one of the categories of
Yes, absolutely.
non-inclusion / deletion.
Which is why I'm reading all of this. There's more that we have to read to you from this act, which is very important. Because the aspect of death or migration, all that is covered by... They were so prescient that there's been no cause to really trifle with this enactment for 75 years, which has kept our democracy intact.
And this entire statutory scheme is
Yes.
again to be read with 6, 7, 8, 9 article. Because
On citizenship separately.
this is dealing with a situation that country was facing in 47, 48 and
No problem.
49.
I would, and this is where I distance myself from Mr. Sibbal's argument, is that I am not looking at the citizenship issue because they are not looking at the citizenship issue. They claim that, look, I can't trust your Aadhaar because I have to look at citizenship. but you've thrown out 65 lakh people not on citizenship. You have a variety of reasons why you have en masse excluded, not individual inquiries, which is what Parliament tells you to do. I advisedly say this. As a voter who was on the electoral roll, this was a very important, integral civil and political right available to me. India prides itself across the world on being the largest democracy in the world. Is this the way the custodian will trifle with us? Individuals like us, hardworking people, including those two individuals who came here yesterday, and millions like them. The election commission is going to be so casual with us, saying, I've sent an enumeration form, fill it up, submit it with documents. Who allowed you to do this? Which law allowed you to do this? Where is the authorization from which you got this? Section 21, please. This is where the preparation revision provision is.
See, there is a deviation from.
So, section 21. I remember the first time, my lords, in July when we argued this, some questions fell from Justice Bagchi on this. I just want to revisit that for a minute.
21.3, if
21, yes.
I am not wrong.
I'll just read all of it. Absolutely. Exactly that and the non-obstante clause. So, that's important. 21 is preparation and revision of electoral rolls. 1. The electoral roll for each constituency shall be prepared. Please mark these words, in the prescribed manner. That's why the definition of prescribed is important. So it can only be as per the rules. It can't be by any third method. In the prescribed manner, by reference to the qualifying date, and shall come into force immediately upon its final publication in accordance with the rules made under this Act. Now this, clause 1 is dealing with preparation. Clause 2, the said electoral roll shall, unless otherwise directed by the Election Commission for reasons to be recorded in writing, be revised. First is preparation, this is revised in the prescribed manner. So both 1 and 2 have prescription. By reference to the qualifying date, you can ignore the rest of it. Once again in 2b, shall be revised in any year in the prescribed manner by reference to the qualifying date if such revision has been directed by the Election Commission, etc. Provided that the electoral roll is not revised as aforesaid, the validity of continued operation of the said roll shall not thereby be affected. So prescription is in 3 places, in 1 and in 2a, 2b. All 3 places prescription. 3. Notwithstanding anything contained in subsection 2. Please note it's only a non-obstante on 2, it's not a non-obstante on 1. The Election Commission may at any time, for reasons to be recorded, direct a special revision of the electoral roll for any constituency or part of the constituency in such manner as it may think fit, provided that, subject to the other provisions of this Act, the electoral roll for the constituency as in force at the time of issue of any such direction shall continue to be in force until the completion of the special revision so directed. So, the non-obstante permits an overriding with reference to revision, which is 2, but doesn't permit an overriding with reference to 1, which is preparation, which has to be by prescription. Prescription is the rules. Rules say nothing about enumeration form and these documents that they have handwritten to advert to.
Right.
Yes. I'm sorry.
You see,
yes, Lord.
1 does not speak of revision.
It does not. I'm great.
2 speaks of revision.
Correct. Correct.
1 and 2.
Correct.
That is the preparation and summary revisions
yes.
are qualified with the word prescribed manner.
Correct. Correct.
Subsection 3
Yes.
correctly
Yes.
overrides subsection 2
Correct.
because it relates to revision and not original preparation,
Correct.
and naturally has an overriding effect over subsection 2
I'm with.
in respect of time and place, because if you see time and place
Correct.
is what is prescribed in subsection 2 for summary,
Correct.
yearly or before an election.
Correct.
3, it is up to the election commission
Yes.
when it is going to do.
Yes.
The thing which actually I put the question which
Yes.
you are making a reference
Yes.
is the words
Yes.
which gives elbow space
Yes.
to the election commission, namely in such manner as it deems fit.
Correct.
Now, it's very easy to say some manner as it deems fit
Correct.
will naturally be the timing,
Correct.
because the timing is prescribed in subsection 2 for summary revision.
Correct.
Timing is not there, and it's totally within the subjective domain of an election commission to decide how, when I'm going to go for a intensive, or as we won't use the word intensive because that's their premise to describe it as intensive. We will use the word special revision.
Yes.
So special revision timing is up to them.
Yes.
Because it's override subsection 2.
Yes.
Mr. Gopal, we would like your point on the word prescribed,
I'm
because
with.
prescribed is specifically in 1 and 2 but not in 3.
So that's
To
what
what extent,
that's what I was coming.
to what, and
Yes.
we go with you and with Mr. Sibal also and the others
Yes.
who have said that yes, under the rules,
Yes.
it said even special revision has to take into consideration rule 4 to rule 24.
Yes.
But when the primary legislation says in such manner as it deems fit,
Yes.
and the subordinate legislation prescribes
Yes.
a proposed manner,
Yes.
but does not qualify it that it shall not be done in any manner other than the proposed manner, will it or will it not give a residual discretion left with an election commission to dovetail the procedure, not completely in ignorance of the rules, but with some more additives than what the rule prescribes, with a slight variation here and there to deal with the peculiar requirements of a special revision.
I think
this is what we would like to do.
It's a very fair and very nuanced question. So allow me to argue it at 3 levels.
Exactly.
So first,
And
yes.
slightly adding to it,
Yes.
whatever 3 was required to be qualified,
Yes.
that has been done with the proviso. That so long as the revision does not, special revision does not take, earlier will continue.
Which is what
So
you're
this
asking
is
for.
the only, yes, this is the only rider legislature thought to impose
Yes.
on subsection 3.
Fair enough. So let me just start just with the very words. The fact that subsection 3 very consciously applies itself only to subsection 2 and not to subsection 1 has to have certain significance. I believe the reason is that it's only when you are doing the revisions as prescribed here, which is under 2, which is effectively from rules 8A to 23. When you are following that procedure, that you can deviate from that procedure for this purpose, only there. But you cannot deviate from it when you're dealing with subsection 1.
You can.
If you cannot deviate it from subsection 1, the inquiry we have today is what the election commission embarking on. Is it effectively under subsection 1 or is it under? In my view, what they are doing, and admittedly, is under subsection 1.
You are positing the power to 1
Yes.
and not to 3.
Exactly. I am saying what they are doing, if it is going to be, and the words used in the rules is important. The word in the rule is afresh. When you say afresh, what is it? It's preparation. It is not revision. You throw everything overboard, you go back to square one, and that is why advisedly it says rules 4 to 23A apply.
Mr. Gopal,
Yes.
in that context, preparation is a one-time exercise. In 1950, the act came.
But the
rules were such a
so there is already a pre-existing rule.
Correct.
Can you say?
So then either
And that's why the word used is special revision.
correct. So that's where the mischief lies. The act doesn't talk of special revision.
Act does.
No.
But it does not is special intensive revision.
Sorry. Special intensive revision is not referred
They are trying to put an additional adjective.
Correct.
The statute says special, they put an additional adjective of an intensive
It doesn't talk about
exercise.
revision. Now, what is the difference? I ask myself. The special revision, special intensive revision.
Maybe that adjective comes from the expressions of the statute in such manner as the commissioner deems it fit. So the commissioner deems a more intensive special review.
Now, all of this, your lordships will note, is rooted in what actually the mechanism is which has been prescribed. The mechanism prescribed, your lordships are absolutely right. My understanding would be that electoral rolls once prescribed, always prescribed.
Always prescribed.
If it is once prescribed, always prescribed, there is no question of going back and wiping the state clean. If your lordships are in agreement with me on this, the entire exercise is void. It's invalid, it cannot be done. Because there is no option. Either you wipe it clean and say, I'm going to every Bihari ordinarily resident there and I'm going to each door under Rule 8, I'm knocking, finding out your residences and filling up the form and coming back. Option 2 is to do the revisions which are provided for under 2 and followed by the rules from 18 to 23.
How to read this condition in subsection 3?
Yes.
You have to go by the language of subsection 3.
Yes. Sorry.
Yes.
It has to be constrained by.
No, of course. Yeah. Yes. Can we be unreasonable? Can we be arbitrary? Can we be discriminatory? The election commission can be all of this. Yes. I'll say that. Oh, yeah. Okay.
Any constituents
If I may, the possibly, and because we're assisting your lordships on an interpretation, I don't think it's adversarial. Let me just
So
look at
nothing is
possible.
adversarial between the senior counsel and the bench. Nothing ever is
Not
adversarial.
between us.
It's the litigants who are adversarial.
No,
Counsels of the judge putting their minds together to solve a litigant's problem. Nothing more than that.
Sometimes you can argue to the discomfort of your client also.
That's the role of a senior advocate. We want your advice.
No, so I'm just looking at three possible answers to the way
Right.
we can read subsection 3. The first answer is by saying that because it overrides only 2 and not 1, as far as 1 is concerned, prescription. Wherever you have to embark, that's a prescription.
It's a first time exercise.
Correct.
That's at the 1950 it was done.
Correct. So,
First time.
if you want to try and attempt something like that again, you have to do as per the
You have to undo all the electoral rolls.
Correct.
They have not undone all the electoral rolls.
That's the issue.
They have put a milestone.
They have.
The
They have.
milestone is 2003.
Whether
that's just, unjust, maybe another
whether they
question.
have the power to do that
Correct.
in view of the constitutional provision is itself.
Right, that's another question that we said. But if you are trying to posit the power to subsection 1,
Yes.
the roadblock that you will hit
Yes.
is the milestone of 2003. So they also presuppose the existence of a electoral roll.
Correct.
What you may debate is why 2003 and not why 2025.
Correct. So this brings me to second possible way of interpreting that section, subsection 3, is that if your lordships, as your lordship just said, subsection 2 is dealing with timing. It's dealing with when. Subsection 3 seems to be dealing with that. So when it uses the words in such manner as it may think fit, it allows the election commission to fix any other time period for running this.
That is one of the species of that scope.
Species. The third is with reference to extent.
Extent, yes.
If you see the words used, it says direct a special revision of the electoral roll for any constituency, any or part of a constituency. So they're actually narrowing it down and saying, notwithstanding 2, you can go ahead with a revision for 1, maybe 2 constituencies or a part of it. Not for reasons to be recorded. Not for the entire country. This exercise which is impugned before your lordship is for the entire country, every constituency in the country. So again the question arises, does 3 deal with granting you the power to do that at all? I'm very grateful for what your lordship said. There is only one original preparatory electoral roll. In which case the question arises, can you undertake that kind of a mammoth exercise to wipe it clear all the way up the blackboard to a year of your choosing, arbitrary as it is? 2003, 2010, 1992. Is that permissible? Does the law permit that? In my view, this section, which is the heart of the case, doesn't permit you to do that. Nothing emanating from here permits you to say, I am taking some marker, drawing a line there, and even though you have been on the electoral roll since then, the other 3.9 crores of you, the onus is suddenly being shifted by us, despite us having looked at your documents, checked your citizenship, verified your qualifications, seen that no disqualifications under section 16 apply, and then having added you in the list. I will now, without conducting individual inquiries as the law enjoins me to do, en masse throw you out. Does the law permit them to embark on the exercise? Because yesterday your lordships asked a very pertinent question. Are we challenging just the procedure? No. Let me make it clear, on our side, we are challenging it from the inception. This is not anything you could have embarked on to start with. Forget Bihar. You could never do this. It's historic for a reason that it's never been done. It's the first time in history a special intensive revision under this garb has ever been done. Intensive revisions were done, summary, part of both, they have been done. First time. And if this is permitted to happen, God knows where it will end.
Then subsection 3 will become redundant, Mr. Kumar.
No, that's exactly why.
It can never be done, then this provision is not required to be there.
Subsection 3 says
So if
per constituency on part of a constituency.
Mr. Gopal, take
Yeah.
your argument
Yes.
to an absurdium.
Yes.
They go constituency wise. Instead of going Bihar wise, they go
Yes.
constituency one.
Yes.
As per your argument, it is permissible, any constituency. Isn't it?
No.
Take your argument to an absurdium.
I'm taking it.
Let
I'm
us say
taking
Bihar
it.
has around 40 odd constituencies.
But
So
I'm
take
sorry.
each constituency
I'm sorry.
and go ahead with the special
I don't
procedure.
think I've been clear then. Subsection 1 is tabula rasa at the beginning.
Right.
Subsection 2 is the power your lordships are talking about. You want to do Bihar? Use 2. There's a prescription. Rules under section 28 are placed before Parliament. Parliament approves it. It has a very high statutory power. Now, are we to believe that this residuary power left with the Election Commission for reasons to be recorded?
So the residuary power has to be read with Article 325. It's a constitutional power expressed through the legislative discretion reserved.
All the more reason is that power so wide that it will override prescriptions in rules laid before Parliament, that the Election Commission can do entirely what it wants.
Definitely that is to be considered. That is to be considered.
So,
But to say that there's one argument to say there is a complete absence of power.
no, I'm not saying that.
There is no
I'm not
complete
saying that.
absence of power.
Because the Election
First-
Commission is
first,
the custodian.
Let us understand your argument. First,
Yes.
you admit that subsection 3
Yes.
has an overriding effect over subsection 2.
Over 2, yes.
Subsection 3
Yes.
gives a special revisional jurisdiction or special powers of powers of special revision,
Yes.
which is definitely different from the ordinary revision which is envisaged in subsection 2.
Yes.
It may be, according to you, not en bloc,
Yes.
but constituency wise or parts of constituency wise,
Yes.
and in such manner
Yes.
as the commission may deem fit and proper.
Yes.
Now, as such manner, you say, must be read with the words any constituency and the timing of subsection 2,
Yes.
and not otherwise.
Yes.
In doing so, we will give uncanalized power, unbridled power to the constitutional authority. That's your argument.
I would not say use the words uncanalized, unbridled.
Uncanalized,
I
why?
think that all power which is exercised by constitutional authorities are tied down by the constitution. So it will be limited powers which are available. For example, they cannot be arbitrary. They cannot say, I am going to...
Naturally subject to judicial review.
Yes.
We mean uncanalized to the extent of not falling ultra vires the statute.
To the extent of the prescription under 2. That's all it overrides. It doesn't override anything else.
That's what you say. You
Yes.
read down such discretion
Yes.
only in relation to the events described in 2 and
Yes.
nothing more.
Correct. So, effectively then, rules 4 to 8 will apply. If rules 4 to 8 apply, it is enjoined upon them to strictly go by rules 4 to 8, while arguendo, accepting the fact there may be an overriding of rules 8A to 23. That's my argument. And I'm saying that subsection 3, for a responsible custodian to whom this power is given, is not to be used in a routine manner. It is to be used in exceptional circumstance. For example, there's a landslide in one constituency. Now you have to then conduct an intensive revision if you have elections coming up to figure out, special revision to figure out, look, what are we going to do? Are you going to follow all the procedures, or if something emergent is necessary to be done, you may do it. That is what this residue is for. It's for that constituency, part of a constituency, which is one narrow way of looking. Second is timing, Election Commission can decide. And they put these down in reason. I don't believe, I'm subject to what your lordship say. The very fact that prescription is provided, the very fact rules are placed before Parliament, means that there are very strong procedures which are laid down, which say that this is how we will carry out the preparation and the revision. And you have gone through the entire gamut of that procedure for 74.5 years without any demur. There's not been a problem on this count. You suddenly exercise this provision in a manner which is hitherto unknown. It is not meant for this. It's an exceptional circumstance where for a constituency or a part of a constituency you will exercise that power. And just to answer my Lord Justice Bagchi's question, it is not that they are deprived of going by the rules and doing the entire state or doing the entire country. That go by the rules. you want to throw the rolls overboard, you are permitted to throw it overboard only as far as 2 is concerned, not as far as 1. Now, if I can just proceed to section 22, which is correction of entries in electoral rolls. Yeah. Correction of entries in electoral rolls is section 22. If the electoral registration officer for a constituency, on application made to him, that's 1, or on his own motion, 2, is satisfied after such inquiry as he thinks fit, 3, that any entry, please mark entry, I'm sorry, not just Bagchi has it, I'm reading 22. Any entry, that's individual entry, in the electoral roll of the constituency, A, is erroneous or defective, B, should be transposed to another place based on ordinary residence, and C, should be deleted on the ground that the person concerned is dead. Surely, whichever way my interpretation on section 21(3) goes,
This is to be
doesn't override 22.
but on his own motion.
Yes, but inquiry. So he has to do an inquiry for 32 lakh people. Have they done?
That is for them to answer.
That's for them.
That's for them.
They have to do individual 32 lakh inquiries in the space of 1 month and then remove them from the roll. If they have done this, it's a mammoth, humongous exercise. I congratulate you. No, I'm already done. Provided
that inquiry, Mr. Gopal, was
Yes.
Dr. Singhvi pointing out their SOP
yes,
of going to the registration of birth and death
Yes.
records and getting it from the birth and death records, the names of the persons, and then deleting them whose names have been struck off as dead persons. And that is how, in all probability, they come to the figure of 32 lakh odd dead persons.
very happy
Don't you
to
tell
give them the answer.
22,
We don't give them the answer, you give us the answers, we just repeat them.
So, sorry.
22 is basically a kind of clerical error.
That is what it is.
Somebody's name is wrongly typed.
Yes.
Somebody's father name wrongly typed, husband name wrongly typed, wife name wrongly typed, something, that kind of mistake. And of course, if somebody brings to notice of the electoral officer that a dead person is also,
Yes.
one of actions can be made.
That's the procedure. Register of birth and death से मिला लेते हैं जो नाम डेथ सर्टिफिकेट है.
Proviso says, provided that before taking any action on any ground under clause A or B or C, on the ground that the person concerned is ceased to be ordinarily resident in the constituency or that he otherwise not entitled to be registered in the electoral roll of the constituency, the electoral registration officer shall give the person concerned a reasonable opportunity of being heard.
At least not to a dead person.
Would not be. It says ordinarily resident.
Shifted person.
Shifted. You have to ensure that reasonable opportunity has to be given. Now, this is what the Act requires. Now, if the burdens of the Act on the Election Commission are so strong, it's necessary for them to adhere to it. Subsection 4 is very important of this same section. Subsection 4. The electoral registration officer may, for the purpose of establishing the identity of any person, require that such person may furnish the Aadhaar number given by the UIDAI as per the provisions of that, provided, this is very important, provided that the electoral registration officer may also require the Aadhaar number from persons already included in the electoral roll for the purposes of authentication of entries in electoral roll and to identify registration of name of the same person in the electoral roll of more than one constituency or more than once in the same constituency. Your own Act requires you to look at the Aadhaar. How do you wriggle out of it among when you have 11 documents to look at? And then intimation under subsection 5.
The purpose of establishing the identity. Sir, Aadhaar is for the fact what is name.
Yes. Related to 23. And section. No. I'm not going back to the phone. Forms is taking it.
I'm to read 24, 25, which were challenging, and they read all of it. But 10 to 12. 10 to 10.
13 is very simple. The communication is very clear. 20.
Will come next week. No, I don't think. It was thinking about it. And once I slowly understand, I think it's so, as far as I'm concerned, once I'm in it, the mechanism procedure is for revision. Yes.
It's like you can see as it feels big monster. Generally, it's people from what is it's not even in the
It can't be.
now. Because iPhone, which they don't
They don't want to payment stuff. Only by mistake say it. You say your stuff.
But section 28 is the power to make rules. 28.2 says it will be placed before Parliament as soon as possible. Now that I've finished with the Act, I just want to say one last thing. That whichever way your Lordships looks at the interpretation of 21.3, two things cannot be taken care of by their interpretation of 21.3. One, my entitlement under 326 once I'm on the roll. That is untouched by this. Second, my entitlement under section 62 of the 1951 Act, which tells me that once I am on the roll, I'm entitled as a voter or an elector. Those two things remain untouched by this, whichever way this interpretation goes, whichever way I want to follow with the procedure. Now, if your Lordship saw the rules, just see Rule 25 once more. You've seen Rule 5, which deals with preparation, Rule 8, which deals with the information to be given by occupants of dwelling houses, etc. Just see 25 for a minute, which is the revision of rules. The Lordships would have noticed that 25.1 says the roll for every constituency shall be revised under subsection 2 of section 21.
25.2 में 4 apply करा है.
25, Rule 25. I'm sorry, I should have said Rule 25, page 62. Page 62 of the same compilation. You have the compilation? Or in the barrack? No, the Lordship will look at the barrack.
Oh, you are.
No, wherever, my Lord.
Sir.
Whatever you might have marked. It's in volume 4A. It will be part 1, page 62. Yes.
1960.
25(2).
25(1) to
2 applies to your case.
yes. Yes. Just bear in mind that the word electoral roll is defined. We know what that is. It is for a constituency which is an assembly constituency. Now, under volume 4A, Manoj, it's in volume 4A, 4 capital A, page 62, part 1, page 62. Yes. So, 25(1) says, the roll for every constituency shall be revised under subsection 2 of 21, either intensively or summarily or partly intensively and partly summarily as the election commission may direct. 2. Where the roll or any part thereof is to be revised intensively in any year, it shall be prepared afresh. Please mark that, afresh. And rules 4 to 23 shall apply in relation to such revision as they apply in relation to the first preparation of a roll. Please mark that. Now,
That is the answer.
that is what I'm saying. Exactly, that is the answer. Once you have said afresh, and once you have used the word preparation of a roll here, it takes you back where? It takes you back to the original.
And that is where we have to read
Yes.
that discretion in the primary legislation
Correct.
with the prescription
Correct.
of 25(2).
Correct.
So the discretion is not, that's why I use the word uncanalized. Is it uncanalized? It's not uncanalized. But there's a difference.
Yes.
The primary legislation gives that elbow space
Correct.
of slight variations, as you say,
Yes.
in a peculiar situation like a natural disaster
Something.
or a man-made disaster, and the intensive role is required to be made. And the commission, in its wisdom,
Yes.
vested by the constitution,
Yes.
needs to make a little deviation from rule 4 to 24. The powers are reserved.
That's what.
But the yardstick of our test
Yes.
as to whether its deviation is just, fair, reasonable,
Yes.
will be rule 4 to
I'm
24.
grateful. And
This
always
is
bearing,
our
that's I'm
assessment
most
of it.
grateful, and always bearing in mind 326 and 60.
Yeah.
And always bearing in mind Article 326 and Section 60.
That is
So
well
bearing
taken.
that in mind,
Well taken, sir.
what is the width of that exercise that is available?
As much as you harp on Article 326,
Yes.
I'm sure Mr. Dwivedi is going to harp on Article 325.
I'm sure.
It's a battle between a constitutional right
Yes.
versus a constitutional entitlement.
Yes.
Their right to superintendence
both the right and the entitlement.
versus your right of entitlement of being on the rolls.
Correct. Now, because it's been interpreted, I'm hoping that I would not have to persuade your lordships afresh. It has already been decided. I'll show your lordships that. Now, the reason I'm showing your lordships 25(2). Well, so the reason I showed your lordships 25(2), rule 25(2), is for the employment of the words afresh and preparation role, as well as the words rules 4 to 23 will apply. Right, Manoj? Now, please just come to rule 4 for me. Rule 5. Rule 5 for me, which is part of rules 4 to 23, which will apply to their exercise. Rule 5 says preparation of role in parts, and then gives the detail of the preparation of. My argument is, by virtue of rules 4 to 23 being made applicable, you have taken us back to section 21 subsection 1 scenario. I hope I'm making myself clear. Section 21 subsection 1 is the 1950 exercise. Original preparation. Your own avenue that you have followed, which is via 21(3), is to take us all the way back there, which the non-obstante clause doesn't override. It overrides only 2, not 1. Since you have taken us back there, as a consequence compulsorily, you have to follow this prescription and there is no other. If I am right on this, enumeration form, 11 documents have no basis in anything. I hope I'm making myself clear. If we then go by the word prescribe and go to the rules, and 25(2) takes me back to Rule 5. Rule 5 tells me that you have to go back to what you did when you started preparing the first rule. If you are going back there, the questions arise in the present scenario. Where is enumeration form? Not mentioned. Where are these 11 documents? Not mentioned. Form 6 is a separate set of documents. Where is the power with you to put an artificial cutoff date saying these older electors who are there till 2003 are kosher? Those after 2003 we are raising a big question. Where is the power for all that? You have to go strictly by the prescription. This is not permitted by the prescription. Now, my lords, just now, if your lordships will take, it's perhaps volume 4A
how
part
much
1.
time, Mr. Gopal?
I'll take about 20 minutes more because I don't think we have shown your lordships two important things. One is that that order of 24th June 25, 2 paragraphs were
Then
read.
how will you conclude it tomorrow and then next week then CB will start?
So then can I'll try
We
and...
need a lot of cooperation from this side because...
No, I know, but I'm wondering, I hope I'm not repeating anything that any of the other council have said, because I believe this is the foundation on which we build the case.
So you can, with your acumen, just state precisely the point.
Let me do that. I'll then shrink it down, but just if your lordship will bear with me, I'll just take point form. If your lordship can just ask them to keep volume 4A and volume 5A. During the break, we asked them to write 4A and 4B in big letters on the cover.
You want to refer now 4A?
4A. 4A, if page 354 is in part 1, page 354.
This is part 1.
Just
354 annexure A.
Yes, that's
24 June 25.
That's the order of 24 June 25. Now, I'm not sure that we have shown your lordships 2 or 3 paragraphs from this because this is what we're challenging. If your lordships will see para 4, this is in line with the objective. They've mentioned several years where they've undertaken intensive revision for all or some parts of the country for, please mark those words, a fresh preparation of electoral rolls. Your lordships have that? So there's no doubt, this is what they're undertaking. It's a 21-1 exercise, a fresh preparation of rolls. In para 4. Then para 6 refers to article 326. Para 7 is their reasons for why they are undertaking this and says migration of population for which there is a prescription that has been followed. Livelihood and other reasons. So the movement is already prescribed, it's covered, they have not followed that procedure. The second is deletion, which is also prescribed in section 22. That prescription has not been followed. Thus, the situation warrants an intensive verification drive to verify each person before enrollment. So suddenly, the onus is shifted from them onto us. If they have to verify, section 28 provides for using the voter ID to avoid impersonation, rule 28, and section 23 permits them to use the other. Both of them have escaped their attention. On para 10, please note that this special intensive revision is for the entire country. What's happened? Entire country.
Yes.
And last line of that says the schedule for the special intensive revision in the rest of the country shall be issued separately in due course. So they're going to do it for the entire country. However, without the schedule coming out, already in missive has come from the CEO of Bengal that they are ready to carry this out. And then your lordships have seen paras 12 and 13, so I'm not going to trouble you with that again. which shifts the onus completely on us for some strange reason, despite us being on the electoral rolls all these years. Right, Vimal? Now, if I can bring you to two judgments, both of constitution benches. The first is Inderjeet Barua, which is in volume 5A, page 19 of volume 5A. Your Lordships have seen Lal Babu Hussain yesterday, the three-judge decision which made it clear that the situation which arises after you're on the rolls, presumption squarely in your favor, that can't be put on our shoulders. No matter what power you have, that can't be put on my shoulders unless you go one by one, each individual. Now, this is at page 19, my lords. This is a situation where writ petitions were filed challenging the elections which had taken place to the Assam Legislative Assembly. From para 1, your lordship will find that, because there was no revision. So they said you've used the 1979 electoral roll, so set this aside at page 21. I just want to draw your lordship's attention to the bottom of para 4, which is at page 22. When I read that, it's about 7 lines from the bottom, the sentence starting all that.
All that the election.
All that the election commission directed the CEO to do was to proceed on the basis that those whose names were already included in the previous electoral rolls. And we may point out that the electoral rolls of 77, on the basis of which the elections by the Assam Legislative Assembly were held in 78, were not at any time challenged by any of the petitioners, should be prima facie regarded as satisfying the qualification of citizenship. And if any specific objection to the inclusion of any particular person on the ground of lack of qualification of citizenship was raised, it should be decided by the appropriate electoral authorities, and the burden of showing that such person was not a citizen should be on the objector. This applies squarely to any other objection you may have once I'm on the rolls. Whatever it is, whether you feel that I'm of unsound mind, that I'm not actually past 18, that I have been involved in corrupt practices, whatever it is, there has to be A, an objector, B, an objection, C, an inquiry. It's on the conclusion of that one person can be removed from the electoral roll after hearing. That has not taken place here. You can't use the garb of a revision to revisit your existing electors who are entitled to be on the electoral roll under section 62. Now, I won't trouble you more with this judgment, Pronounce. This is what I want to rely on. It's a constitution bench in 1985. The other is the more recent judgment of Anup Baranwal, which is at page 240 of the same volume. Same volume, constitution bench. I had the occasion to assist your lordship on empowering the very authority who is opposing me today about who will appoint the election commission. So, lacuna was found in the constitution. A committee was directed to be formed by the judgment of the entire bench, in fact, on that issue. But unfortunately, there's a parliamentary enactment that has come, which has undone what your lordships did. However, the majority merge of starts with Justice Joseph's judgment, speaking for the four of them, at page 291. Will your lordships kindly have that?
Page
291. And there is a helpful index which is set out at page 291 of the various aspects dealt with. Please come to the heading S for Shimla. Article 326 demystified. Lordships have it? That's on the next page, 292, in the middle. It starts at para 150, which your lordships will find at 359. This is the majority judgment, speaking for four, while Justice Rastogi has a separate judgment. The editorial notes here seem to suggest that he has disagreements at some point. If I can bring your lordships to para 150, it's at the bottom of page 359.
Article 326 demystified.
Demystified. Now, I won't again trouble your lordships. All these articles are set out, etc. Please come directly, my lords, after an extensive discussion on how Article 326 operates, and then at page para 164, section 62 is set out. If I can show your lordships para 166, interpreting section 62. If I may just read that.
Yes.
In our view, the meaning of section 62(1) read with 62(2) is the following. To cast the vote, a person must be included in the electoral roll of the constituency. However, even if it be that he is so included, if at the time of the election when he casts the vote, he has incurred any of the disqualifications referred to in section 16, then his right to vote will stand eclipsed. And then please come, my lords, after detailed judgments have been considered, para 180. This is a detailed analysis because there's a paucity of time. I'm not troubling your lordship with everything. They went through all the judgments on the point. Para 180. Having noticed, this is at bottom of page 369. Having noticed all the relevant provisions and bearing in mind the characteristics of a legal right, we find as follows. Since every legal right, which would include a constitutional right, as the constitution is also law through the Grundnorm and not law for the purpose of Article 13, must have a title. We must ascertain whether a citizen of India who is not less than 18 years, as on the qualifying date as found by us, has a right. Since the title to a legal right means the facts or events by reason of which the rights become vested in its owner, who is the person of inherence, we will explore whether Article 326 contains the facts and reasons and whether it also contains the content of a right. In keeping with the mandate of Article 326, Parliament has made the 1950 Act and the 1951 Act. It is thereafter that the first general elections were held in the country. It may be true that the 50 and 51 Act have been amended from time to time. At any given point of time, placing 326 side by side with the law made by Parliament or the law made by the state legislature, we would find that if a person is a citizen of India and not below 18, and if he does not incur the disqualifications, which cannot be more than what is provided in Article 326, but the content of which may be provided by the law made by the competent legislature, and the citizen not less than 18 years does not have the disqualifications, he becomes entitled to be entered in the electoral roll. Such person, as is indicated in Article 326, indeed has a right which can be said to be a constitutional right. Unequivocally, my right to be included in the electoral roll is a constitutional right. I want at this point to draw a distinction with right to vote being a constitutional right. The reason I say that is that I would be remiss if I didn't show you what they say on the next page. So, if I can show you what they say, Malas, at para 185. We have noticed that we cannot and we did not finally pronounce on this aspect being the question of whether it's a constitutional right to have a right to vote. In view of the fact that a constitutional bench of this court, which I have noticed in Kuldeep Nair, has proceeded to hold that there is no constitutional right. What is important is that the court noted in Anupur that holding of free and fair elections constitute a basic feature of the constitution and approved of the view apparently that the right to elect is fundamental to democracy. Even if it is treated as a statutory right, which at any rate cannot be divorced or separated from the mandate of Article 326, the right is of the greatest importance and forms the foundation for a free and fair election, which in turn constitutes the right of the people to elect their representatives. We would, for the purpose of the list in question, rest content to proceed on the said basis. If I can pause for a minute, there is hence very clearly and unequivocally in para 180.2 the statement by them that subject to the disqualifications provided in 326 and the statute, a constitutional right to be included in the electoral roll. To be included in the electoral roll. If they went further and said you had a constitutional right to vote, then the challenge could be raised by somebody sitting in prison saying, I have a constitutional right to vote, you are depriving me by way of a statutory provision. Which is why the court advisedly makes that distinction. You have a constitutional right to be included in the electoral roll if you don't fall foul of the disqualifications. Once you have that constitutional right, I ask myself, and this is what the majority says, Justice Rastogi goes one step further in his concurring to say, notwithstanding the decision in Kuldeep Nair which cast a doubt on the constitutional right, he says after the privacy judgment, etc., he seems to liken it to a central constitutional right. Now this is aspect one, that my right to get on the electoral roll is a constitutional right by a recent judgment. If it's a constitutional right, how do you take it away, that constitutional right I have? It is only if the disqualifications have been incurred or the statutes provides the mechanism. Clearly, that doesn't apply to the 65 lakh people as of now. The reason I say as of now is that however generous that draft electoral roll is, by the end of this month, if all those documents which are required to accompany the enumeration forms don't come in, it will be 65 lakh plus. It may be 1 crore, 1.5 crores. In the judgment which your lordships were shown yesterday in Lal Babu Hussain, it was 1.69 lakh. That's all it was. 1.69 lakh, your lordship said, the onus is on them once you're on the roll. So today I will not take more of your time. I also want to point out that the same point comes up as far as the state of Bengal is concerned. I have put a compilation up on behalf of the state of Bengal which shows that on 8th of August, the newspapers carry news saying in Bengal, the chief electoral officer of the state of Bengal says, we are ready for the special intensive revision. So the additional chief secretary writes, I put the correspondence there, but I'm just summing up, your lordship may take it when you have time. Additional chief secretary writes to them on the same day, saying, chief electoral officer, how are you saying we are ready? Under the act, I have to be in consultation with you to get my people in the state ready to carry out this exercise of yours. At which point a document of the same day is issued saying, no, we are going to initiate this intensive revision in the state of Bengal. This is on the 8th of August, which is why we didn't have the opportunity of placing it before and we have placed it now.
Bengal can wait, Mr. Gopal.
It can wait, but what we are seeking from your lordships today is threefold, and I want to just highlight that. When this matter first came before your lordships on the 10th of July, your lordship said, in the interests of complete justice, twice you used that word justice. Your lordship said that they will use the Aadhaar, they will use the ration card, and they will use the EPIC ID. In that shocking counter affidavit of theirs, they specifically give reasons why they will not use any one of those three. They say that you need other documents in support of that. These are not permissible. EPIC, in fact, renders the entire exercise a nullity. So that's the first exercise, apart from the impugned one, where despite your lordship's nudges, and I find it insulting, honestly, that after your lordships have mentioned three documents and said in the interest of justice for all those poor people in Bihar, that please consider these three documents, they thought it did not deem fit for them to do it. And then we specifically said on that date that we are not pressing stay. We are pressing stay today, and we are pressing stay of this impugned notification, which is a national exercise. So Bengal will benefit, other states will benefit in whatever manner. The very inception of this exercise has no basis in the constitution or in the laws. It doesn't. You cannot take me off an electoral roll by putting your cutoff date at 2003. You have taken me off it. 10 elections have taken place. We have given a list of those. All those 10 elections I voted. And today you say, petitioners 2 to 5, Mr. Singh. So we have taken part in these elections, and now you tell me you're not on the electoral roll, come and prove yourself all over again. Goldfinger, who is a character in a James Bond film, says,
now going by this contention, then it can't be done at in any part of the country.
Any part of the country. 100% it cannot be done. At the inception, it's dead. It's stillborn. There is no question of doing this exercise. Your Lordship Justice Surya is absolutely right. It's a one-time exercise done in 1950. You cannot use that as an excuse to completely rework the clock and start off again. What is this? Where are we headed with this? This exercise is not contemplated at all. And even if you contemplate it at some level, an exercise which involves bodily, en masse, taking people off the electoral roll
But
is
Mr. Gopal,
fully
all said and done, voter list can't be a static list under subsection 1.
That's why revisions, Manoj. I'm not saying you can't revise. Of course, every year for the state of Bihar, 2016, 17, 18, 19, 20, 22, 24 and 25, they carried out revisions. What were they doing in those revisions?
One-time exercise is only for preparation of the original one.
Exactly.
Thereafter, whether you go under 2 or 3, that's a different issue. There has to be revision.
Yes. So now, the central aspect is once I am on a roll, I have an absolute right on that roll. The only way you can remove me, and Anup Karanwal's majority is very clear, that my constitutional right cannot be taken away from me by way of a fig leaf of an enumeration form that they have come up with. I believe that considering that they have violated your lordship's order at an ad interim stage of not even honouring those 3 documents, they don't deserve any longer rope balloons. Please stay in this exercise once and for all. I'm grateful.
It won't take much time, I'll definitely finish by 4 o'clock. But what I'm requesting is, Your Lordship, if Your Lordship can sit for half an hour extra today, this side will finish.
We'll try to finish. Maybe that will give 5 minutes little.
Yes. So I won't take Your Lordship through the document. The arguments are very simple, my Lord.
In fact, otherwise you can refer to documents because by now we have a fair idea of the documents and we can note down also.
Yes. So, my Lord, if Your Lordship sees the form for Form 6, which is the form for including a first-time voter, it has 3 requirements. One is that you show some evidence of your place of residence, show some evidence of your date of birth to make sure you are above 18, and for citizenship, just make a self-declaration. That's what it contains. Thereafter, it has to be challenged.
That we are referring to Form 4.
Form 6.
6.
Form 6.
New and
Thereafter, if somebody wants to challenge my citizenship, they have to challenge it by filling up Form 7. I have to be informed of the reasons why it is being challenged. I have to be given an opportunity, and thereafter, a decision has to be made. After giving me notice, giving me a full opportunity to present any evidence. And Lal Babu Hussain has pointed out that all evidence has to be considered. Now, so far as, now in Lal Babu Hussain, my Lord, Your Lordship saw that though it was not styled as an special intensive revision, but because mass notices were given to 1.67 lakh people, saying that we are questioning your citizenship, therefore you come and show your passport or your birth certificate, etc. The court said you can't do that. You have to presume somebody was there, he was there legitimately, and therefore if you want to remove them, you have to give them a notice with reasons as to why you are suspecting that citizenship, and then allow them to present any documents, not just these documents that you have prescribed. Not just documents, any evidence. I would go so far as to say that a declaration, if a declaration is good enough to show my citizenship for a new voter, certainly that declaration is good enough to show my citizenship if I am an existing voter. That has to be the case. So therefore, thereafter somebody challenges that and shows some evidence to show that I should not be considered to be a citizen, then certainly they can give me a notice with the reasons, etc. and go through that process. But not in the manner in which they are doing. Just see what they are doing. There are 8 crore, roughly 8 crore voters. Now they have reduced it by 65 lakh, they are saying 7.24. Even among these 7.24 who they claim have filled up their forms, enumeration forms, for 2 districts we have seen, as Mr. Yogendra Yadav pointed out yesterday, 10.6 and 12.6% are not recommended by the block level officer, booth level officer. Now, They told.
Just percentage again.
So out of these
So
7.
Darbhanga and one more.
More.
Let us take as a pilot project.
Yes, yes. In these 2 states, some whistleblower gave us this data about the PLO's recommendation. So there is a chart which we have annexed, that is at page 803 of volume 4A, where the booth level officers have written recommended, not recommended for each person.
What is the percentage with your point out?
10.6 in one district, 12.6% in another district.
Not recommended.
Not recommended. However, in some particular booths, not recommended are more than 90%. Only 10% recommended and more than 90% not recommended.
So that 10 point something is the average.
Average.
Oh.
That means that if assume that these 10.6 to 12.6%, let us assume that this is the average. This percentage of voters have to be given out of the 7.24, have to be given notice to ask them why they should not be on the electoral roll, and they have to be heard. Who is to do this? The electoral registration officer. He has to take the final call. In one constituency, there are 3 lakh voters. 3 lakh voters. There are 20 working days in which he has to do this. Out of these 3 lakh, even assuming that he gives notice to these 10.6 to 12.6%, which means about 30,000, let's say 10%. He has to give notice to 30,000.
Exercise will have to confine to only those 10-11% only, because those who are recommended, unless the superior authority take a contrary decision, that will have to be accepted.
Yes. Now the first question is, my lord, what is the basis on which they are recommending, not recommending? No guidelines, no rules, nothing. The 11 documents, I can guarantee if your lordship asks them to give how many people have submitted even one document out of these 11, I can guarantee that there are not more than 25% people whose enumeration forms have been received who have submitted even one document, because we know for a fact that these enumeration forms were filled up by the booth level officers sitting in their offices. We have put it on record. We have given videos that these officers were filling up the enumeration forms and signing them on behalf of the voters. That is why, my lord, large number of dead people have found their way in this electoral rolls which we have given. Large number of dead people have found their way into this, whose forms have been filled up. How? Because the forms have been filled up not by those dead people, but the forms have been filled up by the booth level officers sitting in their offices. This is the manner in which, my lord, this whole exercise is being done. Now the question is, no rules, no guidelines. If less than 25% people have submitted even one document, on what basis is the booth level officer recommending or not recommending? How has he recommended for 90% people, not recommended for 10% people? What is the basis? No basis whatsoever. And these 11 documents are not proof of citizenship. How is residence certificate a proof of citizenship?
No, none of these documents can be proved.
So they are at best evidence of either place of residence or evidence of date of birth
or identity.
For citizenship, Lord, Lal Babu Hussain and their own SOP, etc., makes it absolutely clear that citizenship you can't decide. You have to presume if somebody, unless you can decide only in such situation where somebody challenges your citizenship. Somebody has made a self-declaration or somebody is already there on the electoral roll. His citizenship is challenged by somebody filling up Form 7. And then
You have to give notice, you have to hear him, take any evidence that he gives, including his affidavit. Suppose he has no document. He only gives his affidavit and the affidavit of a couple of neighbors. Unless that is refuted in some way, that should be good enough. Because, my lord, in this country, large number of people don't have a single document. In this also, out of these 11 documents, we have shown that only the matriculation certificate is possessed by about 40% people. But the other documents are possessed by, in totality, more than 50% people don't have a single document because there is overlap between scheduled caste OBC certificate and matriculation certificate. The same people who would be having matriculation certificate may also be having OBC certificate, etc., OBC caste certificate. So therefore, in the absence of any documents, ultimately what will you do? You have to only give a affidavit or an assertion or a declaration, and that's what Form 6 provides that. Therefore, this exercise that they are trying to do, where even assuming that 10% people are to be given notices, 10% means 30,000 people per constituency. You will give notice to 30,000 people, hear them, decide in 20 working days. And when you publish the final electoral roll, there is no time because elections are notified by that time, and therefore this appeal, first appeal, second appeal is meaningless. And therefore you have achieved a fait accompli by finalizing the electoral roll in this totally arbitrary manner. Your Lordship has held in my written submissions, I have mentioned those cases where this arbitrary, completely unbridled, uncanalized power has been held to be illegal. This kind of arbitrary power to recommend, not recommend, decide on what basis? No guidelines, nothing. Nothing. Suppose they had said that all right, if somebody produces this, then you consider him. If somebody doesn't produce this, then you don't consider him, etc., etc. One could have understood that there is some rationale to this exercise. There is absolutely nothing. And the mala fide nature of what the Election Commission is doing is clear from four things. Number one, my lord, their insistence on doing this hurried exercise, even for Bihar, in 2 months, which they had earlier frowned upon repeatedly. They had said that only 6 months is left for this, or only 4 months is left for this election. We won't do this intensive revision for these dates. Number two, my lord, their refusal to accept Aadhaar, the ration card and the voter's card, despite by saying what is the reason? They say this is not evidence of citizenship. As if these other 11 documents are evidence of citizenship. They are not, except for birth certificate and passport, none of the other documents are evidence of citizenship. Even prima facie evidence of citizenship, if those are prima facie evidence of citizenship, certainly Aadhaar, ration card and EPIC are certainly evidence of citizenship. And secondly, my lord, citizenship is not something that they can decide. At best, they can raise questions about citizenship, refer it either to the Foreigners Tribunal or somebody else. It's not the job of the Election Commission to decide. Thirdly, my lord, their refusal to even put out the names of the persons, say 65 lakh people who have been deleted on a website, and the reasons for their deletion, they say they know the reasons. They have given to the last voter 32,67,403 people who are permanently shifted. So many lakhs, so many thousands, so many people who are dead to the last person. Therefore, they have on a click of a button everything, the whole list of 65 lakh. And the reasons for each one of them as to why they have been deleted. And their refusal, they are saying we will not do it. Why? because they say we have given this information, and the information that even they claim to have given is not the information with the reasons for the deletion. Only they say that they have given the list, the booth level list, to some booth level agents of the recognized political party. Why should a voter have to go to booth level agents of recognized political parties to find out whether his name is there in the deleted list or not? And why have they, Lord, earlier the list of this 7.24 who find themselves in the draft roll, it was searchable. You can do Control F and you can see if your name is there in this list or not. This was removed deliberately by the Election Commission after the 4th of August, so that nobody can even search to find out whether his name is there in the deleted, in the draft roll or not.
This list was earlier on their website.
Yes, yes. It was on their website in which you could search. Now that from the draft roll,
the site has only final electoral rolls. Draft rolls are not submitted. On the one hand, they say that people do not have digital facilities. Now they say at one click of button, the person in the village, the little man, will find out what.
So therefore, my Lord, this I can show. I have both. What existed prior to 4th of August and what is there now. What existed prior to 4th of August is a list of the draft roll which is searchable. They have not put out the list of the deleted people, the 65 lakh deleted people. They had put out the list of the people on the draft roll. Prior to 4th August, it was searchable. I could search for my name by putting Prashant Bhushan, Control F, and I could see whether I figure in that
7.24.
7.24 or not. Now they have removed that. Why? And they removed it one day after that press conference of Rahul Gandhi on that Karnataka election. Exactly one day, the very next day after that press conference, this was searchable function was removed from this list of the draft electoral roll. And the fourth thing is, my Lord, so why I am saying, my Lord, that
we have no knowledge of any press conference situation.
Your Lordship may not have. He had held a press conference in which he had known that there were more than 1 lakh duplicate voters.
Unfortunately, Election Commission can't respond to.
That's all right.
As per rule, the draft roll is to be published in the electoral registration office like this. This is the notice to the electors. Notice has been prepared in a
The registration of electors rule 1960.
Yes.
And that rule 10 contemplates publication of the this draft electoral rolls in the office of the
electoral registration officer.
Electoral registration officer. That is what Form 5 says.
Yes.
Referable to Rule 10. Please, both sides you confirm tomorrow. And just find out that whether it has been published in their office.
I can demonstrate that that was there on their website. It was a searchable list and it has been now.
Mr. Bhushan, since the argument is that they should strictly adhere to Rule 4 to Rule 24.
No, that's not the only argument. That's not the only argument.
No, we are indicating to you the website publication is definitely welcome because it is more accessible to a wider number of voters, individuals online. But the statutory requirement, minimum statutory requirement is Form 5.
All right, maybe.
Rule 10
What
Form
I'm
5.
That is
this, my Lord. If this is available to them in electronic form and it can be put up on a website, why should they not do so? Why should they say that we have given booth by booth information to the agents of recognized political parties only? Why should they say that about the deleted 65 lakh? Why should that 65 lakh not be on a website if they have that information? And they say that they have the exact information for the reasons of deletion. Why should that not be on the website? Why? Lord, obviously this shows a mala fide intent. The fact that they have resorted to all these things, that is, not put up the 65 lakhs on the website, remove the searchability function from the 7.24 crores in the draft electoral roll, refusal to accept the Aadhaar card and the Epic card and the ration card as even evidence of some kind to show place of residence or date of birth, etc. And their insistence on doing this exercise in this unseemly hurry, where it is impossible I say, for any person, any human to do this exercise in such a short time of doing all this. So quite apart from all the reasons which have been mentioned, the legal reasons why this exercise is illegal ab initio, I am saying that the manner in which they are doing this exercise is completely arbitrary and seems to be mala fide. And we have shown that sometimes below 240 people are in this draft roll with the same address of one house. How? 240 people appear in the draft roll in one house. So many dead people, many alive people who are not in this roll, dead people who are in this roll, all
that are alive, 240 can't be in one house. I mean,
yes, it can't be, obviously. Obviously. Then lastly, my lord, the interim order. Now I know that your lordship may not be able to conclude the submissions of the election commission, etc. This week, because tomorrow is a miscellaneous day. I don't know, my lord, how much time your lordship will be able.
I will talk to right now. We'll talk to registrar and we'll request the member of the bar that except urgent bail matters, we will not take up any of them.
I'm glad, my lord. What I'm requesting is that at the very minimum, even if your lordship cannot hear the election commission this week, the very minimum interim order that we need, the minimal interim order is they should put out the list of these 65 lakh, which is in our IA. They should put out the list of this 7.24 crores with searchability function, and they should put out the names of the persons recommended and not recommended that they have. It should put them out on the website so that people know that they have not been recommended, etc. And the reasons for deletion. That is, in that 65 lakhs, they know so many dead, so many shifted out, etc.
So there can be a separate list of the dead persons that will itself be their reason.
In that list, they should. They have
list of dead, list of shifted, list of dumped.
So therefore, my lord, what I am requesting is that this is the minimum that they must do, even if your lordship is not able to conclude the.
No, we will conclude, may not be, but briefly we will try to hear them out.
I'm grateful for the time, because I'll be very swift. Because my submission is, because I'll just begin by answering the court's question with Mr. Narayanan Madhav. Are we against revision? Because firstly, we are against special intensive revision. Our case is that this special intensive revision has never been done, and that is deholds the act and can't be done. It is not our case because the election commission has done historically many intensive revisions. They have happened.
Has never been done may not be an answer, but it cannot be done. It cannot be done an argument.
I'm grateful. So therefore, it is also never been done and cannot be done. I'm grateful to the court. Because I'll begin by my Lord Justice Suryakant's judgment in the 6A matter. Because I'll just place that two paras very quickly. Your Lordship was speaking for the Constitution bench in that matter. Because para 333 at page 77. Give a copy to the other side. Because your Lordships were interpreting 326 in this para. And I think the words are very, very potent. Page 77, my Lord.
77 handwritten.
Handwritten 77, yes. It's the same page number, even otherwise. Handwritten.
Yes.
And Malons have said, after examining 326, I'm only reading in the interest of time the relevant portion. Para 333. The objective of these provisions, and more specifically Article 326, is therefore to enfranchise people as opposed to disenfranchising them. That's the way the lordships in a constitution meant have read 326.
Absolutely.
And Malons, thereafter, as illuminated by the historical trajectory of adult suffrage in India and the meticulous deliberations of the framers in stating Article 326, the evident purpose of its inclusion was to bestow upon every individual citizen the right to exercise their vote and choose their elected representatives. Hence, in contemplating the contentions put forth by the petitioner, the question which arises is whether a right under Article 326 can be invoked to exclude certain individuals. Just one more para 335, below that. Primarily, the considerations of the Constituent Assembly during the discourse on the right to vote emphasize that determinations regarding disqualifications and exclusions from the right to vote should be outlined by the legislature through suitable statutes. In this context, focused deliberations were conducted, particularly addressing the prescription of qualification for right to vote, with Dr. B.R. Ambedkar asserting that the establishment of such qualifications ought to be entrusted to the legislature. Similar observations were articulated by other members of the assembly. Well, let's pause here. I will straight away take your lordships to the act itself. Well, this is the first question, the first case in my understanding where the role of election commission in citizenship is coming sharply before the first case in my understanding. But the answer in my respectful submission of what is the role lies in the 1950 Act itself. Kindly have section 16 of the 1950 Act. I just read two sections and possibly that gives an answer.
Disqualification.
Yes. A person shall be disqualified for registration in an electoral roll if he, A, is not a citizen of India. I'll just underline two things. It is a disqualification. It is not a qualification. It is a disqualification. So something will turn on that. B, is not a citizen of India. So you have to prove that he is not a citizen of India. The point I am making is, and there is no other section which says that you have to be a citizen of India to be on the roll. That's the point I'm making. It's a negative. It sounds negatively very consciously in 16. Now your lordships will read 19. Conditions of registration. Subject to the foregoing provisions of this part, every person who is not less than 18 years of age on the qualifying date and B, is ordinarily resident in a constituency shall be entitled to be registered in the electoral rolls for that constituency. My Lord Justice Bagchi said we should read 16 and 19 together. Because when we read them together, what is the conclusion? That the condition of entering the electoral roll is if you are an adult and you are residing there, you are in the roll. You don't, the election commission is not required to check if you are a citizen of India in light of what is 16. The citizenship status of election commission and what it can do only comes if you are in the roll and it has a reason to suspect. Then, like everybody else has said, you give a notice and they lock them out. You cannot construct a notice down upward based on citizenship. That's in the teeth of 16 and 19. I submit respectfully. And your lordships were asking what is the scope of power under 21(3) as it deemed fit. That will necessarily take its flavor from 16 and 19 as well. So that's my respectful submission. Well, that's on one. Well, now I would submit your lordships. That's the second point. I'll conclude with that. Plus, really speaking, what has happened in this matter, this whole draft vote. This draft vote, as everybody has argued, has already excluded 65 lakh people. Plus, the draft vote, in my respectful submission, has to be, in any given case, always the existing rule. The existing rule has to be the draft rule. Because if we don't, what happens is a situation like present, that you can exclude people before the draft rule and they have nowhere to go. What has happened in the present case. So, the existing rule has to be under Rule 10, what your lordships were seeing earlier, has to be taken as the draft rule. Then, Rule 21 in that is about inclusions. Rule 21 capital A is about deletions. You include, you delete, you do it intensively like Lord Justice Bagchi said, you can do it as intensively. But you begin, where is the beginning point? The beginning point is the existing rule. Beginning point can't be 65 lakhs people didn't give me the form, out you go. That's plainly wrong. So, I submit therefore, 65 lakh people have already been illegally removed. If your lordships were to even consider allowing it, they have to be brought in the draft. If this process has to go on in any manner,
that 65 may include dead also, Mr.
Yeah, that's all right. But after that's all right.
Don't ask us to bring the dead people.
But the election commission will delete the dead flow process.
Yes, but what about people born? They are not included.
Plus, as per the record, they were alive on 24th June 2025. Now, if they have passed away, no difficulty. The election commission must remove them. But through the process envisaged in the law, not through this thing that people did give me forms. We don't know today. Those numbers are being thrown.
Your point is understood.
Yes.
Therefore,
the lordships will have to include them if your lordship even were to consider going forward. That's my respectful sir.
Thank you. Thank you, Mr. President. Yes, Mr. Sen.
My learned friend have to leave.
If Bengal can wait, please. Bengal can wait for the time.
I have to leave.
So we will request you to come again, please.
Next week I can come.
We are not sure about next week. I am in constituent bench, and next week, in any case, we will not take the matter. Bengal can wait, please. We will fix a date, and
I have no objection.
We will invite you, and we will hear you definitely. We can assure you, we will hear to the extent you want. But
no, I don't have much blood since
just like you accommodate us also, we are accommodating.
Since you have always been spoken.
Bengal can, for the time being, wait. Let us finish.
What has happened? Bengal has started already.
So what?
And started already. The unfortunate part is shared the one incident. Unfortunate part is this: within 3 days, large number of electors have been deleted, and 3 women, yesterday in front of Calcutta High Court wanted to commit suicide by pouring kerosene.
You see,
that's it. That's now.
We will not take. It's very difficult for us to examine individual claims. Let us be.
Individual.
The 3 excluded, 100 included. That will be very, very difficult for us to. We will go into the broad principles. Broad principles will be same in the case of Bihar. Almost same will apply to Bengal. But depending upon the local conditions, if there will be additional.
Just 2 or 3 points.
No, please not today.
One point, just 1 point. Then I will argue later.
If you will argue later, then why this 1 point today?
Seems that this is not been pointed out to us. That's the reason. Rule 26A kinds.
No, read please.
I will argue later. Read Rule 26A. The list of amendments prepared with reference to the qualifying dates as specified in Sub-Rule 1 shall be merged and integrated with the last finally published rule and published as draft rule under Rule 10 before every election and by-election and shall be put in public domain with reference to qualifying service. Therefore, 2025 rules have been merged with all that.
We'll examine that.
Rule 26A. How, even in a special division, how they can ignore Rule 26A?
Only.
Rest I will make my submissions later, whenever you are.
Yes. When the turn of Bengal comes, then we'll hear you.
Madam.
Just wait for a minute. Yes, Mr. Sen. 2 minutes.
Yeah. Not more than 10. Even less likely. I won't take it. So, I'll just wrap it up as quickly as possible. I'll concentrate on the other aspect. The citizenship part has been very good. The other reason given in the order is frequent migrations which have taken place in the last 20 years. So what becomes crucial to understand is habitual residence in that place. Now, if we start with page 403, volume 4A, I just want to point out 403, volume 4A, part 2. That was the press release after the SSR was carried out. They say all addition, deletions, etc., everything has been done, everything is perfect. Suddenly, my lords, the abruptness of it is very disconcerting. Suddenly, somewhere in June, they suddenly decide that an intensive revision has to be done all over the country. If my lords, we see 403, my lords, everything has been done. That road is in place, and in fact, as pointed out, 21.3 proviso. That role, in fact, continues today to be valid. In fact, that could be a way out at the moment in this impasse. Why
why duplicate? They mentioned that duplicate entries, doubtful records, admitted, verified, deleted. That's at page 403, 404. They say completed, various names of voters were added and deleted, no appeals have been filed, etc. Now, my lords, if we come to no reasoning given, I mean, my lords, there's a judicial review possible, no reasoning given as to why that SSR was inadequate. What were the inadequacies? What prompted them to suddenly, after 20 years, say that 20 years there's a problem, now we want to take an overall exercise. So, my lord, that is the first part which is pointed out. Now we come to, I want to focus on, my lords, the habitual residence chip. Now, it's a more complicated exercise than simply looking at documents. When you are doing an intensive revision, as I understand, the BLO will have an electoral roll in his hand. He will go house to house for enumeration. He will talk to the people there. There will be a discussion, whether as per that roll, who is there, who is not there, that exercise has to be undertaken. Today, instead, what they are doing for habitual residents is that they have said, give us an enumeration form, and there are all kinds of discrepancies pointed out, going only by the process they have put out. They say, please give us the enumeration forms, we will decide on the basis of that. Now, habitual residents, whether you, it's a slightly complicated exercise for two reasons. Number one, if you look at, their own requirement, their own guidelines, which talk about determining residence, and for that, may I just point out, page 189, volume 4A, part, yeah. Just a few pages of their own guidelines on how this exercise is a more complicated exercise. Can't be done in the short timeline and intensive revision. Yes. Yes. Sees determination of ordinary residence. Originally in the Representation of People's Act, it was provided that a person should ordinarily be resident in the constituency for not less than 180 days during a prescribed qualifying period before his name could be registered in the constituency. However, this was done away with by an amendment at 56. But the concept of ordinary residence has not been defined clearly anywhere in the statutes. Section 27 of the Representation of People's Act 1950 provides that the electoral registration officer shall determine a question as to whether a person, where a person is ordinary resident at a relevant time with reference to all facts and to such rules as may be made by the central government in consultation with the Election Commission. The central government and the Election Commission may not have made any rule on this subject.
We expect them that they will follow their guidelines. How can they ignore?
No, they would follow their guidelines, but why admittedly their cases, they look at the enumeration.
They don't know what is admitted, but they will get a turn and
as per the counter affidavit,
we'll ask them some questions, yes, and then we'll come to know what is admitted, yes, and what is denied.
But what they are saying in their counter affidavit is we'll go by the enumeration forms. And if you submit documents, it is fine. If you don't. Now, another aspect is this, because of the short timeline. And one more thing, they talk about the Manmohan Singh judgment, etc. Which points out that it's in the negative. The fact that you have a house there doesn't mean that you're ordinarily resident. The fact that you don't live there doesn't mean that you're not ordinarily resident. All those case laws are there. Kuldeep Nair case, I won't take time, I'll give those three citations. Kuldeep Nair case says, concept of what constitutes residence can change from time to time. So if they are saying in the last 20 years there has been a shift in migration, etc., this is the heart of the exercise to be carried out. And it is an exercise which can only be carried out on a door-to-door enumeration. Now, they also say, a second part, they say so many lakh booth level agents have been appointed. But if we see, because of the short time, there will be a greater reliance of these booth level agents and officers. They are political parties. It's a different aspect, I will not point out, but in the relevant page of the counter, one party has a disproportionately large number, 50,000. The next has 16,000. When there are such short timelines, there is bound to be reliance on them. Volunteers and booth level agents of political parties. How kosher will that exercise be in an intensive revision is an issue which beggars the imagination. Because if this exercise has to be carried out on a door-to-door basis, it is not possible in that one month which is there. So, that aspect also has to be seen. Second, accountability. The BLOs which are appointed are government officials which are appointed. If anything goes wrong, they are accountable. What is the accountability of the BLA and the volunteers who are there? So, that's the other point which I was pointing out, that this in a short span, this exercise, pushing it through is not. Now, my lords, may kindly see What are the other kinds of exercise which a BLO has to do? I'll just finish within 2 minutes. One is, for example, the BLO has to verify addresses given in Form 6 at night. There are homeless people. Right? These are there in the guidelines, I'm not reading. There are homeless people, for example. How do you determine what their residence is? They don't have a house. So at night, a BLO has to make not 1, 2 visits to check what the residence. Illegal colonies. There's this talk about enumeration being given. It's an established practice, my lords, and perhaps that needs to be changed maybe, that many times, if a municipality has not given a house number, there are ad hoc house numbers given for the purpose of residence. If there's an illegal colony, the municipality will say 0 for the house. And therefore, again, that has to be verified. So it's not just looking at...
These are the challenges any administration will have to face, and they will have to find out a solution also.
Yes.
These are practical challenges, we understand that.
Yes.
But somebody will have to find out a way out also. These are not something that there is no solution to these problems.
No, in fact, I would suggest the solution is this one. As it fell from this bench, my lords. 21.3, if we look at the scope of discussion, in the circumstances of this, is it a reasonable exercise they are carrying? I don't want to stop the intensive revision, as my learned friend from the other side said. We say it's welcome, but it has to be carried out in a timely fashion, in the manner. In the meantime, my lords, there is, of course, a stay. My lords, ideally, my lords, until this issue is decided, there should be a stay. But my lords, the other option is, my lords, 24.3, the proviso says that the existing rules are valid. If we look at the interim, we are looking at interim orders. If the balance of convenience is in my favor, from years these rules have been existing. These rules are valid as per Act. So the Act has contemplated you can keep on carrying out intensive revision, but continue the elections as per the earlier rules. But these are the submissions.
Thank you, Mr. Swan. Mr. Pasha, we'll hear you all. Mr. Swan, will.
Wait,
and where is Rashmi Singh? We'll hear you also, because the only women lawyer from this side. We can't ignore you. Madam Brinda, of course. Yes, Brinda led them. Yes, I forgot. But today, in a way, I stand corrected. Today, she is the only one in the list before us. How much? 5 minutes?
10 minutes. Just take 10 minutes without any repetition.
Oh, like 10 minutes and so you? No, not little longer, nothing. Oh, like 7 minutes. 10 plus 7 and Dr. Swan, you also want to ask? 5 minutes? No. Please see the situation also we are facing. So
where they have been trying to put the constitution in the place.
maybe that again we might require to give an opportunity, largely only with reference to the nature of interim directions or interim arrangement that we are praying for. Ultimately, we are considering in that context. So maybe 5-7 minutes should be sufficient. And Madam Rashmi, how much time you want? Madam Fozia, do you also want? How much? So like 5 minutes? 5 minutes. No, we'll give you 5 minutes. So 10 minutes, 10, not more than 10, and 10 you adjust all of you. So half an hour tomorrow, we will give on this side, and then we will start. No, it's all right. Our show is not over at 4:30. The other side will start now. I mean, that's. So we'll try to start tomorrow by 11, maximum 11:15, and then let us see that. There is no need to repeat, because that we can assure you, we are noting down everything, and our staff is also working, they are also noting down.
So I am very restricted to putting things, and then I just repeat.
Likewise, tomorrow, I revise my written submissions every evening, cutting out whatever has already been argued.
Tomorrow we will try to start at around 11, between 11 to 11:15.
Very well. Grateful, Lord.